The U.S. civil court system resolves non-criminal disputes between individuals or the state, while civil rights are the fundamental freedoms and protections guaranteed by the Constitution and laws to ensure equal treatment and liberty under the law. The role of the U.S. Supreme Court as set out in the Constitution is to interpret the Constitution, act as the final court of appeal, and ensure that laws and government actions comply with constitutional principles. The nature of the U.S. Supreme Court is independent, where justices are protected from political influence through life tenure and secure salaries, allowing impartial decision-making. What is the judicial review process of the Supreme Court is the authority to assess laws and executive actions and declare them unconstitutional where they conflict with the Constitution. The case of Marbury v. Madison 1803 shaped judicial review by establishing the Supreme Court's power to declare acts of Congress unconstitutional. The case of Fletcher v. Peck 1810 shaped judicial review by extending this power to state laws, confirming that state legislation could also be reviewed and struck down if unconstitutional. The appointment process for the Supreme Court is where the President nominates a justice, the Senate Judiciary Committee holds hearings, and the full Senate confirms the nominee by a majority vote. The strengths of the appointment process are that it involves both the executive and legislative branches, promoting checks and balances and democratic accountability. However, the weaknesses of the appointment process are that it can become highly politicized, leading to partisan conflict and delays in filling vacancies. The factors that influence the president's choice of nominee are political ideology, likelihood of Senate approval, judicial experience, age, and the desire to shape the court's long-term direction. The current composition of the U.S. Supreme Court is 9 justices appointed for life, including 1 Chief Justice and 8 Associate Justices. The current ideological balance of the U.S. Supreme Court is a conservative majority, reflecting the greater number of justices appointed by Republican presidents. The impact of the U.S. Supreme Court on public policy is that its rulings can fundamentally change the direction of government policy by upholding or striking down laws and executive actions. An example of this is Dobbs v. Jackson Women's Health Organization 2022, where the court overturned Roe v. Wade and allowed individual states to set their own abortion laws. Another example of this is Students for Fair Admissions v. Harvard 2023, where the court ruled that race-based affirmative action in university admissions was unconstitutional. The political significance debate is the argument over whether the Supreme Court acts as a neutral interpreter of the Constitution or as a political actor shaping policy outcomes. Judicial activism is where the Supreme Court takes an active role in interpreting the Constitution in a way that leads to significant changes in law or public policy. The criticisms of judicial activism are that it undermines democratic accountability and allows unelected judges to impose their own values rather than reflecting the will of the electorate. An example of the Supreme Court demonstrating judicial activism is Dobbs v. Jackson Women's Health Organization 2022, where the court overturned long-standing precedent and reshaped abortion policy across the U.S. Judicial restraint is where the Supreme Court limits its role by deferring to elected branches of government and avoiding broad or far-reaching constitutional interpretations. The criticisms of judicial restraint are that it can allow unconstitutional laws to remain in force and fail to protect minority rights. An example of the Supreme Court demonstrating judicial restraint is Moore v. Harper 2023, where the court rejected the independent state legislature theory and avoided radically altering the balance of power in federal elections. Civil rights and liberties can be protected by the Constitution, the Bill of Rights, constitutional amendments, and rulings of the Supreme Court. The rights and liberties that are protected by the Constitution are fundamental principles such as separation of powers, federalism, due process, and protection from arbitrary government action. An example of the Constitution protecting these rights is Trump v. United States 2024, where the Supreme Court clarified the limits of presidential immunity to uphold constitutional checks and balances. The rights and liberties that are protected by the Bill of Rights are freedoms including speech, religion, assembly, a fair trial, and protection from unreasonable searches and punishments. An example of the Bill of Rights protecting these rights is New York State Rifle and Pistol Association v. Bruin 2022, where the Supreme Court strengthened Second Amendment protections on carrying firearms. The rights and liberties that are protected by constitutional amendments are equality before the law, voting rights, and protection against discrimination based on race, sex, or age. An example of the constitutional amendments protecting these rights is Allen v. Milligan 2023, where the Supreme Court upheld the Voting Rights Act to protect minority voting rights under the 15th Amendment. The rights and liberties that are protected by the rulings of the Supreme Court are those interpreted and expanded through case law, including privacy, equality, and procedural fairness. An example of the rulings of the Supreme Court protecting these rights is Department of Homeland Security v. Regents of the University of California 2020, where the court protected the rights of DACA recipients by requiring lawful decision-making by the executive branch. The methods used by racial rights campaigns are protests, legal challenges, lobbying, media activism, and grassroots organizing aimed at highlighting racial inequality and pressuring policymakers. An example of this is the Black Lives Matter protests in 2020 to 2021, where mass demonstrations were used to demand police reform and racial justice following the death of George Floyd. The influence of racial rights campaigns is that they shape public opinion and place sustained pressure on governments to address racial inequality through policy change. An example of this is the introduction of the George Floyd Justice in Policing Act in 2021, which was influenced by racial justice campaigning even though it did not ultimately pass. Racial rights campaigns are effective to a greater extent as they can achieve concrete legal and political outcomes by mobilizing public support and influencing institutions. An example that proves this is the Supreme Court decision in Allen v. Milligan 2023, where racial rights advocacy helped protect minority voting rights under the Voting Rights Act. However, racial rights campaigns may be effective to a lesser extent as strong political opposition and institutional barriers can limit long-term policy success. An example that proves this is the failure of the George Floyd Justice in Policing Act after 2021, despite widespread campaigning and public support. The impact of racial rights campaigns on domestic policy regarding voting rights is that they have sought to challenge voter suppression laws and protect minority electoral participation. The impact of racial rights campaigns on domestic policy regarding affirmative action is that they have defended race-conscious policies, although recent court rulings have limited their success. The impact of racial rights campaigns on domestic policy regarding representation is that they have increased awareness and pressure for greater racial diversity in political and judicial institutions. An example that shows the impact of racial rights campaign on domestic policy is the confirmation of Ketanji Brown Jackson to the U.S. Supreme Court in 2022, reflecting sustained advocacy for greater racial representation. The interpretations and debates of the U.S. Supreme Court and Civil Rights Center on whether the court acts primarily as a neutral judicial body or a political institution, and how its constitutional interpretations either expand or restrict civil and constitutional rights in modern society. There are arguments that the U.S. Supreme Court is more political than judicial. The arguments that the Supreme Court is more political are that justices are appointed through a partisan process and often decide cases along ideological lines on highly controversial issues. An example that shows this is Dobbs v. Jackson Women's Health Organization 2022, where the conservative majority overturned Roe v. Wade in a way that reflected ideological divisions. However, that arguments that the Supreme Court is more judicial are that it bases decisions on constitutional interpretation and legal precedent rather than party loyalty. An example that shows this is Moore v. Harper 2023, where conservative justices rejected the independent state legislature theory despite political pressure. The idea of the living Constitution is that the Constitution should be interpreted flexibly so that its meaning can adapt to modern values and changing social conditions. The idea of originalism is that the Constitution should be interpreted according to the original meaning intended by the framers at the time it was written. The arguments that the living Constitution goes against originalism are that it allows judges to reinterpret constitutional principles beyond their original meaning, increasing judicial discretion. An example that shows this is Obergefell v. Hodges remaining influential in later rulings over the last 5 years despite criticism from originalist justices. The arguments that the living Constitution does not go against originalism are that broad constitutional principles were intentionally framed to allow flexibility over time. An example that shows this is Bostock v. Clayton County 2020, where the court interpreted the Civil Rights Act consistently with constitutional principles while applying them to modern contexts. Civil and constitutional rights have been upheld by the Supreme Court to a greater extent as the court has enforced limits on executive and legislative power. An example that shows this is Department of Homeland Security v. Regents of the University of California 2020, where the court protected the rights of DACA recipients. However, civil and constitutional rights may have been upheld by the Supreme Court to a lesser extent, as some rulings have reduced previously recognized protections. An example that shows this is Dobbs v. Jackson Women's Health Organization 2022, where abortion rights were removed from constitutional protection. The Supreme Court protects civil and constitutional rights to a greater extent, as it can strike down laws that violate constitutional guarantees. An example that shows this is Allen v. Milligan 2023, where the court protected minority voting rights under the Voting Rights Act. However, the Supreme Court protects civil and constitutional rights to a lesser extent, as it sometimes defers to state authority even where rights are limited. An example that shows this is Brnovic v. Democratic National Committee 2021, where restrictions on voting laws were upheld. The U.S. Supreme Court has powers over civil rights to a greater extent, as it has judicial review and the final authority on constitutional interpretation. An example that shows this is Students for Fair Admissions v. Harvard 2023, where the court reshaped national policy on affirmative action. However, the U.S. Supreme Court has powers over civil rights to a lesser extent, as it relies on other branches to enforce its rulings. An example that shows this is ongoing state-level resistance to federal voting rights protections after 2021. The Supreme Court has effective checks and balances, as it can limit the actions of Congress and the President through judicial review. An example that shows this is Trump v. United States 2024, where the court clarified constitutional limits on presidential immunity. However, the checks and balances may not be effective, as justices are unelected and hold office for life with limited accountability. An example that shows this is public criticism of the court following Dobbs v. Jackson Women's Health Organization 2022. The measures that the Supreme Court has taken to promote equality include affirmative action and immigration reform. The successes of the Supreme Court's measures of affirmative action are that they supported diversity in education for many years, as seen in Fisher v. University of Texas 2016. However, the failures of these measures are that they were significantly weakened in Students for Fair Admissions v. Harvard 2023, limiting their future use. The successes of the Supreme Court's measures of immigration reform are that it protected immigrant rights by requiring lawful executive decision-making, as seen in Department of Homeland Security v. Regents of the University of California 2020. However, the failures of these measures are that the court has allowed stricter immigration enforcement to continue, as shown in Biden v. Texas 2022. Thank you for watching this video on U.S. Supreme Court and civil rights. I'll see you in the next one.